Are you a parent navigating the complexities of co-parenting, family court, or even domestic violence? If you are looking for ways to help protect your children and build a strong and supportive community around you, then look no further. Gray Minds Think Alike is your go-to resource for everything related to the complexities of family life. Join us as we dive into thoughtful conversations with experts and explore practical tips and strategies for tackling the challenges of parenthood in the throes of adversity so that no parent feels alone and every child's safety is protected. Hi everyone, happy Friday. Welcome to Gray Minds Think Alike. Today we are talking with attorney Robin Scher. Robin has been an active and dedicated member of the family law section of the Florida Bar and serves clients from Broward County to St. Lucie. I've spoken with Robin periodically over the years since Greyson's death, and she has been an advocate for Greyson's law and works with many cases involving domestic violence and sexual abuse. So thank you so much, Robin, for chatting with us today. I'm sure we have a lot to discuss since we last spoke. So how are you? And if you can tell our listeners a little bit about your background, we can start there.
Sure. Robin Scher. I have a private practice in North Palm Beach, Florida. I am practicing now. This will be my 34th year. I am a member of the Palm Beach County Bar Association, the Florida Bar Association, and the Supreme Court. I was sworn into the Supreme Court U.S. Supreme Court in 2015. It was an honorary swearing in. It was awesome. I have been in private practice since I began in 1990 in Florida. I started my practice in Broward as a private guardian ad litem. There was a tight market. I said, let me go learn the system because I'd never practiced in before. I had no family that was in the business, and I had gone to law school in Tallahassee. I came back home, lived at home for a little bit. That was my first foray into the legal field. And I thought, what a great way to meet the people involved and apply the law, learn the players and so forth. And I did that for a couple of years. I really enjoyed that. And eventually I found myself here in Palm Beach County and working for Guy Haynes, who eventually became a chair of the family law section. And from there, I was in private practice. I've worked with several different firms, but midway into my career, I started working at Legal Aid. And the majority of my practice at that time, because one of the criteria for representation is you are a victim or survivor of domestic violence. And that was a criteria, a way to narrow the client pool, because there are so many needy people in Palm Beach County who need legal representation that can't afford it. But there has to be a way beyond the finances to narrow the scope. And there were only 3 attorneys at that time that did all of the divorce work for Palm Beach County. And eventually I went into a program that was in Riviera Beach, that was in the community. I worked within the space of the Florida Resource Center for Women and Children. And we were street level, meet the clients where they are in hopes of getting them to reach out for services, not just their social services, but the legal services. And in that program, I did their domestic violence work as well as their family law cases. That stayed with me as I moved on. I left there in 2006. I've worked with several other firms since, but I've always been a legal aider at heart, and domestic violence has always been at the core of what I have worked on going forward. The majority of my cases presently have some component involving domestic violence. Either they're currently involved in a situation or they have been through a situation involving domestic violence. And I don't represent just women or just victims. I represent as well the accused, we call them, or perpetrators if they've been deemed to be. And I have my position on the entire subject is you can't treat half the problem. And I think that the system has been so focused on getting resources and providing help to women leaving that they don't do enough for accountability and to provide resources to the abusers so that they can, because all you do is free them to abuse the next person. If they don't get the help that they need to stop being abusers. And it's a controversial position, but I believe that most abusers, and I was a presentation I was listening to earlier today defined abusers this way. Most abusers themselves have been victims at some point in their lives, either as where abuse was going on in their household, were exposed to it, they lived in violent communities, they were exposed to something that was how they learned and emulated someone or some way of
Right.
being to say this was okay. And somehow this was the way to deal with things. And I have a friend of
Right.
mine who used to be she spent the majority of her life as an advocate and ran a couple of different domestic violence programs. And she, in her later years, opened up, studied, and became a better intervention provider. And the shift in her perspective after spending all of those years working with victims was so enlightening to see that these guys mostly, but she's had women abusers as well, were at their core victims themselves. And they never learned how to deal with any of whatever it was that got them there. And when, of course, you add drugs or alcohol, other stressors to life, you resort to almost an instinctive behavioral pattern that you may have been fighting against your whole life until you're shown another way. It takes a very strong cord person who truly wants to change to make that transition. It's not an easy change. And that's where you get
Right.
the once an abuser, always an
Right.
abuser. And maybe that's like an alcoholic, once an alcoholic, always an alcoholic. But change is possible, but you have to really be committed to making it. And I think it's so difficult that the numbers of people that actually do are infinitesimal compared to the numbers of victims that continue to exist. And those that don't
Right.
ever overcome their abusive tendencies just continue to abuse the next victim and the next victim. And I think that's a big part of what I'm trying to do is address all of that in the way I practice. And not just in the sense, not just representing them, but in the other work that I've done. For example, when I was asked to join Palm Beach County's Domestic Violence Coordinated Community Response Team, which was originally funded and has been continued funded by VAWA and the Battered Women's Justice Project, which is amazing. One of the things that was most important to me was that we do, in fact, deal with that side of the problem, that you have not just accountability, but you deal with if there are extension services that are needed for somebody that completes and really cares about not being that person anymore and wants to do the work, that those
Right.
things are available, that there's a better
Right.
understanding of what makes the abuser in order to eventually try to keep people from
Right.
becoming those abusers. And they're realizing it. And that's what I think is left of what used to be called the cycle of violence. It's the passing from generation to generation, because that
Right.
cycle is no longer the one that was historically used through the Duluth model, and that whole process is no longer the one that is favored. It's really more of a pattern or the implementation of the coercive control and the broader spectrum of what is abuse beyond just that one day we're great, the
Right.
next day we're not, and then you're getting the apologies and that cycle. They've moved completely away from that in most sociological circles, as I understand it, from the trainings I've been through.
Get abusers that push back because I'm sure a lot of them push back.
They do. So how I look at it this way is you've got your and in the work that we do in domestic relations, you've got the spectrum from the isolated incident where somebody has just snapped or they grabbed their phone and it was reactive and it's that kind of thing. And now just taking the phone from someone is a crime. And does that person without another or long history, do they really belong in jail? And obviously you're not taking it lightly. You're looking at an overall picture of the family situation. And I'm not a criminal attorney, so I'm not going to talk about it from that perspective. But what we look to do is try to make this what is a best decision, a best result for the family in the long run. If you've got a historic abuser who has all the traits, maybe has only been physical a few times, but has all of the other control components. They've damaged things. You know what you're looking at. You know what I mean? Those people deserve to be treated in a very different way. And the system should treat them appropriately, the way they should be accordingly.
Explain, how would you have
So, was there physical abuse to you?
physical?
From a
Yep.
criminal perspective, I don't think there would be anything. But from a civil perspective, I think you're right. And what I think has happened is that finally the system has evolved enough, but more so since then. We needed one more incident. We didn't have enough. We just needed one more to show us how. And so, as to the point, there's so much more research now out there, and cases like yours and several others around the country have really brought this concept to bear, where these laws are being changed state by state to recognize. And I have always said this to my clients: there are innate defense that comes to the mothers of their children with the fathers who've been abusive to the mother, that, oh, but they're good fathers. They're good fathers. And I deadpan say, no good father abuses their child's mother. They're not good fathers.
They're not good people in general.
Correct. But my point only being that there's that defense. They want to say they're good fathers because they don't hurt the child, but that's because there's a lack of understanding with many victims or survivors. They're surviving the victimization by their abuser, that the extent to which that behavior impacts their child. And the average person doesn't know that under the law, if there's domestic violence going on in the home, that it is considered child abuse under the law. DCF is its own anomaly, and whether they will do anything about that is another story. But under Chapter 39 in Florida, which is the child welfare laws, it is defined as abuse when there is domestic violence. The child lives in a home and witnesses domestic violence, and they're called out almost every time, or they're notified when when there's been a domestic violence call and there were children. They get notified if the restraining order is filed and there's a child named in there. There's been a child involved or has bore witness. The clerk's offices in Broward and Palm Beach automatically send those restraining order petitions to the department for them to investigate. Where you have cases where the mothers, we'll use that as the general scenario, the mothers don't seek injunctions for protection or don't seek assistance from the courts to remove the other party or progress to protect the child, if you will, and there continues to be domestic violence, then there is a statutory provision under Chapter 39 that allows the department to go in and file a restraining order on behalf of the child because the parent won't or hasn't. But if there is a parent that is acting on behalf of the child, so they've gone ahead and filed for the paternity or a divorce, and child custody is going to be determined in that context, and the child is no longer living under the roof with both parents, as far as they're concerned, in most cases, it seems, they're done because the child is being protected by the parent because they've engaged the court's sources.
Okay.
For many years, the judges didn't get.
Now, how do they quantify domestic abuse?
And there is a provision in the law as well that there is psychological abuse that is also considered abuse of a child. And so the sad part is when you have social workers who are investigators who are out there, half the caseworkers are not getting paid a whole heck of a lot of money. They're coming out of school and they're going and taking these jobs to get their experience. It's hard work. There are multiple cases. They're not trained to the level that they need to be to understand. They don't necessarily do trauma-informed care themselves in the way they handle families, and neither do the investigators. They take very hardline approaches. They don't meet the family where they are. They don't necessarily look at all of the picture, the cultural norms of the family, and in order to recognize what some of these things are and to educate on the appropriateness. And the law is black and white. So when you deal with something like domestic abuse in the big picture, it is a number of things that a police officer can't necessarily spot when they're sitting there in a single incident. Their job is to do X. And they see that's why there's a mandate if there's obvious evidence of abuse that somebody gets arrested. That's a black and white line they can see and deal with and move along. They can give support to the purported victim by providing them with information and guidance and resources, and then it's up to the victim to do that. How the department handles
Okay.
it on their end, I don't know, because I've never worked that angle of the case, but I have had conversations over time with various caseworkers. So the department can get involved. They can threaten, they have no real power at the outset. People think they do, but they really don't. They're no different than law
Okay.
enforcement in the sense
Right.
that a parent doesn't have to talk to them. They don't have to
Okay.
do drug tests. They don't have to let them in their house. They don't have to do any of those things. And some parents know their rights and they won't. And now what happens, the tendency is you've got something to hide. They're not given the same level of, they don't get their rights read to them like if a police officer was investigating and reads them their Miranda rights before they start questioning them. They don't do that,
Right.
even though those questioning situations are often there. So in our experience, when we've had clients where we've spoken to them while there's in advance of, or we go to the DCF meeting with DCF, or while they're being interviewed at their house, we're very cautious. We've prepped our clients. We're very cautious as to what they can or can't say, because we do know the next step for them, if they feel like you are hiding something, is they can attempt to file a shelter petition, remove the child, and then force the rest of the issues. Now, whether they will do that in an abusive situation all depends upon, I think, the level of knowledge of human behavior, understanding the dynamics of abuse, the whole manipulation and the control and the power, and how these things are dealt with when they're interviewing the kids, which is their primary focus. They sometimes will do it at the school, or they will
Right.
take them in another room. And kids are so worried in those circumstances, and they're not usually prone to lying. People think that they lie all the time. They don't, but they're wanting to protect their parent. And they will often, I
Right.
think, deny that there's any abuse going on to protect their parent, unless there has been something very severe, long term, and I don't want to see my mommy cry anymore kind of thing. And they know that this could do it. But if there's one word
Right.
said between the time they're coming and they get there by that abusive parent that scares the Jesus out of them, they're not saying a word. And it's up to the investigator to know, to understand that what's happening there, and to watch and understand the child's behavior and in their body language and those kinds of things. It's a hard thing to put on a 4-year-old, and they're supposed to ask them in a trauma-informed way, open-ended questions. They're not allowed to feed them any information in the way they question them, and that's an art form. That's not very easy to do, but they have to learn.
Yeah.
They have to do it.
Right.
Otherwise, you're tainting the information and the evidence that could potentially get you where you need to go. It's not an easy situation under any circumstances.
I know at the police, they would not help me because they literally just said, this is a family court issue and you're going to have to get an emergency pickup order. And they did not want to touch it. They looked at my mediation agreement or the timesharing agreement and they wanted nothing to do with it.
Correct.
And they could
That
have
is
saved
civil.
Greyson's life, perhaps, but they didn't.
And that is a standard practice in all departments, in that he didn't come back with him in a timely manner. And that's a civil situation. They will never get involved. The only way they would get involved is if you do the emergency pickup order, a request for, and you've laid out that emergency on an ex parte basis, and the judge says, yes, this child is at risk, issues the order, then that's an order to law enforcement to assist in the return of the child. And if you don't know what you're doing in the drafting of that, just like people do with their restraining orders, that's why they do have the option of coming back and doing an amended if the first one doesn't go through. It's 90% of the time it's because they wrote it in a poor way. And it's not because they didn't know how to properly lay out the facts to give the court. And it's not a lawyer persuasion thing necessarily. It's just that they're writing like they're thinking or like they're talking, and it doesn't come across to meet the criteria that the court needs to make its emergent decision. Because parental rights and a restraining order regarding a child are perceived to be of the highest order of rights in this state. They're not privileges, they're rights. And we could argue that all day long. For some people, it should be a privilege, frankly. And so,
1,000%.
yeah. And so this is one of the reasons that the advocacy organizations, and I don't remember if it was before or after the coalition dissolved, but they went and they all got monies. They applied for grants to put attorneys on staff so that the advocacy organization can now have lawyers to assist in the preparation of those petitions, because that was where a lot was failing. If the petitions aren't done right, you lose right out of the box. So I spent a good amount of time going through a ton of facts. I write 10-page petitions. I don't care that the judges don't want to read them. I know that if I go to court and if you don't plead it, you really can't talk about it at the hearing. That's the law. So I make sure I cover as much as I can and in as much detail as I can in order to ensure that it gets issued on its initial submission, because we all know when you try to leave, that is the most dangerous time for a victim. And if they don't waive the hearing, which the statute doesn't provide, just so you know, the allowance of a hearing to be waived. If the court denies the injunction because of they don't see an imminent threat, the resolve to that is they set a hearing anyway, so that the victim can come and present the evidence of the threat and why a restraining order is needed in the grand scheme of things. Because I won't say nobody,
Okay.
Some people strategically pursue the injunction in order to get the first 2 weeks out of the way for whatever reason. But in general, they're not filing them just for that. They want to move on and get the extended order. So most circuits have created an option that if you are denied your injunction from the initial and you don't get a temporary restraining order, you can basically dismiss it at that point and it never gets sent to the respondent. So they don't know you tried to get one and didn't. The statute doesn't. This is something that's been created to give people an out, because some people are so afraid, rightfully, that if they find out, that's going to be a whole other problem for them. And I can appreciate that. So that is an out that is given in most circuits. But otherwise, they will find out, and you need to deal with what you need to deal with. The other thing that has become a big issue that I'll just take this opportunity to address because it needs to be, and hopefully next year I'll be working again with the chair of the family law section to address this, is if you file for a restraining order in the state of Florida, the fact that you filed is not public record until service has been effectuated. That ends with the DV case proper. The problem is we have so many unreported and people who don't want to get the restraining order for whatever reason, but they're still in abusive relationships that are in just as much danger if they file for a divorce or they file for a paternity action. And there has been permitted in this state now for probably almost a decade, like with traffic tickets. If you get a ticket, the next day you have in your mailbox 100 flyers from different traffic lawyers. That is happening with family lawyers, and they don't do them just from your local area. You could get letters. There's a company that does them you sign up with this company and they'll do the solicitations. You pay them to look at the filings of the day before, and they can go and they'll send to the other party before they've ever been served. And that is
right.
Every lawyer that I know acknowledges the potential danger that puts a victim in if that is happening. Or in one case example, and I've been collecting for years all these stories as to why this is so dangerous. One case that the mother had serious mental health issues, and the mail came to that house and the kids got the mail. If the father hadn't shown up, who knows? And they were very concerned that the mother was going to do something drastic. And what we now have to do is we have to tell our clients right up front, you need to be very sure of when service is going to happen, because within 24 to 48 hours, they will be most likely notified that you have filed if they haven't been served, and they'll ditch service, or who knows what they'll do. And the danger is there. All right, we got a bunch of different topics there, but all related to safety.
Well,
and that's really,
yeah, no, on that note, when Greyson died, I was getting things in the mail from probate attorneys saying, we're sorry of the loss of Greyson. Like, they had no idea that this was a 4-year-old murdered and how sensitive it could be to me. They just mail out things left and right. And I found that to be very violating.
It is. And I miss the days when I first started practicing, you still were not allowed to advertise. Back in the 30 years ago, you could not advertise for legal services. It was considered solicitation. And then it evolved into the TV ads, mostly by personal injury lawyers, who of course maintain that market because it's a very expensive market or means of marketing. There have been so many lawsuits around the country for violation of the First Amendment rights to advertise, seek an interference with their business, to solicit. So they've had no choices in the matter. The bars had to do that. They've put in place, where it's going to be public interest over business or publicity, First Amendment, that because most people don't forget that your a right ends where somebody else's begins. And the state interest in protecting its citizens has always been the guide for why they didn't allow solicit. They thought lawyers that did that were just, it wouldn't be to the benefit of the citizenry. And eventually the courts have said otherwise, but where we're here with the domestic violence, they can say they have that basis because they do understand and recognize the statistics of the detriment to the victim who seeks to leave is much greater, or the percentage of danger is higher at that point. What we're trying to do is create a situation where we can carve out a criteria for the clerks of the state of Florida to keep those filings private until service is effectuated in cases where there have been domestic violence petitions filed, or there is an active domestic violence petition. If there's an allegation, a sworn allegation of a history, there should be some things that allow for the court to say, okay, we're going to chalk this up to another couple weeks, isn't going to hurt anybody. The lawyer's not going to lose their right to file the case. Once it's of record, they can all have at it. So that's hopefully something we'll be able to bring to bear in the next few years, because it really does. I get letters all the time from other lawyers on that subject.
One more thing was that Greyson's father, obviously, my injunction was denied. So it's not that he got notice of it. He had a tracker on my car and he tracked me to the courthouse. So he put 2 and 2 together, and that's how he knew that I was filing the injunction.
I see. So the tracker was both your cars or just yours?
The tracker was just on my car.
And was your car titled in both your names or just yours?
No, we were never together. We never lived together. We were never married. We were nothing to each other.
But that is now a crime. It was not a crime a few years ago. That in and of itself is now a crime. Although I don't know that it would have mattered, quite frankly, because those are all things
fucking.
No, putting the tracker on the car itself is a crime. It's not his car. He can't do it. But it didn't used to be.
No, I know. It was illegal when it happened. I brought it right to the police when I found it, but they didn't do anything.
Okay.
They just filed a report. They filed a report. They took the tracker. They put it in evidence, and
they weren't going to submit it to the state attorney's office to see if it should be.
I mean, it may have gone further after that. Greyson died the next day.
Well,
but at that moment, they should have maybe followed me home.
You would think. But what we have learned through the last few years in particular, maybe going back in the last 10 or 12, because we had a year in 2012 in Palm Beach County, we had multiple domestic violence deaths that year. People really started to pay attention to the trainings, always asking why. I'm not going to diminish this in any way. I don't diminish what's happened, but look what's happening with gun violence. It's the same thing. Every time there's this reaction, and then time passes and we've got other drama that has to be dealt with, and no problem ever gets finally solved or fully solved. It still tracks on through. It takes years to get resolved on any of these matters. The one thing I can say is, in thanks to you, and quite frankly, thanks to Greyson, his death is not in vain at this point. He is really, you and he are doing your level best to protect as many people, as many children as you possibly can, so that it doesn't happen again. And we all owe you a gratitude for that.
Well, that's the goal.
I know. I appreciate that very much. And I appreciate the opportunity to be here to be able to talk about other things that are happening in ways that we can continue those efforts. The only other thing that I had really wanted to talk about is where I see things are really starting to churn up in the world outside the courtroom is the lack, I don't know about lack of tolerance, but the rising intolerance of the way the system is dealing with mostly mothers these days who are trying to protect their children, and how everything continues to get flipped. And the system is becoming a perpetrator or a co-perpetrator with the abusers in what we call legal abuse after the fact. And Darvo is alive and well and the mothers are winding up being jailed. They're gag ordered. They're petrified that they're going to be gag ordered or jailed, that the system in their perception is so stacked against them. It's heartbreaking, quite frankly. I've been doing this for 30 years plus. I have never felt more disheartened by the system than I do now. I always believed in the system. I've never believed in it being biased per se. There was mothers are favored, mothers are favored. I never believed that. I always believed the large part of it was that it was lawyering. And in most cases, that if you present the evidence, you present the case, and you do a good job as the lawyer, that you're going to get a fair trial and the result will be as it should be. Now, that may be a little Pollyannish, I understand. Over time, you come to learn that you cannot remove the human equation from the legal system. And although I would never want it any other way, judicial discretion is bound in the judicial person making that decision. So where there is leeway and the interpretation of the information that's being set, you're probably always going to get a mixed bag from one jurist to another. There are things that have been tightened over the years to make it better. But what I'm seeing is the lack of understanding of what is being presented to them and the lack of ability to present the information, because you almost inevitably have to have an expert to do it. And the financial resources are not there. The system is not set up to, and no one is running to provide these experts, and experts aren't running to volunteer pro bono their help, no matter how much they want the system to be different or they want to help victims of domestic violence. They're not offering their services for free. And the resources that are available from the legal end are limited. But if there was a better understanding of what happens mentally, emotionally, physically, physiologically to a victim of abuse after being within that life for, it doesn't even necessarily have to be a long period of time. And the brain of an abuser, the impact on the child. Most everybody understands what ACEs is and how that affects the child long term. I used to question former Chief Justice Barbara Pariente, God bless her. When she was Chief Justice of the bench, her goal was family. She was very focused on family law. She wanted therapeutic jurisprudence in the family law court in the worst way. She tried every which way that she could, and comes forward 20 years later or plus And she's absolutely right. The only way to do this and take care of families, if that's your goal, even in the dissolution process where your focus is the adults with an eye towards still what's best for the child, you have to know what's standing in front of you. The continual rotating of judges in and out of family, the continual placement of judges who are brand new to the bench and no knowledge on family law, the lack of mandate of training in issues like trauma informed care, like domestic violence and the impact of this trauma. All of these things are what's coming to a head now, and you're seeing so much of these cases where women are losing their children left and sideways. If it's not from the system, it's from, like Greyson, it's from death. He's not the first child to die at the hands of the other parent, because whether they had mental health issues or not, that's only a factor. That doesn't change a typical response to someone with mental health issues. That is an abusive mentality who's out to hurt you and you alone and doesn't care about taking the child with him. And I'm starting to really see that perspective more and more because I've spoken to more of these people who've been through this process this way. I've been exposed to a lot more of that side. I've looked at cases, and it's very easy to blame this or blame that, but I think the bottom line comes to the same. We're all trying to solve people's problems that are way bigger than us. And if we don't understand and I use the term loosely, mental health of the people that we're dealing with at the time that we're dealing with them, we're never going to do justice for any of them. And we're just going to continue the cycle of your kids are going to be screwed up and wind up in therapy for 20 years trying to undo the damage that you tried so hard to protect them from.
Sure.
And that the court and the lawyer, and I see this in the lawyers, they don't listen to their clients. They don't hear with trauma-informed ears, and there's a lack of tolerance. I have clients that I'm on 2 and 3, on the second or third lawyer, because the ones they've had before want to treat them like every other client, and they're not every other client. And if you don't understand that, then do them a favor and help them find someone who can deal with it that way. And it's not to say there's anything wrong with them.
Last time we spoke, you said there's not going to be many changes in the system, but there are going to be improvements. And I think one thing that should improve is the training. Even with Greyson's law, the lawyers, the judges, they try to use it. They have no idea what it is. So unless we get the proper training, these laws mean nothing. They mean absolutely nothing. So I know Caden's law, which is a federal law, funding in each state to get the training is what we need.
Yes, well, but what it trains them on is that I don't know if it goes far enough, but it's much better than not. If you just understand that the trauma part of it and you treat the people with a level of understanding or respect, because I find that to be sadly much more common. There's a total disrespect for people who have to find themselves in this position, as if everybody wants to be there. And it's really disturbing.
And nobody believes the hysterical woman. Right.
No, it's true. It's very true. And what I've also found out is that one of the worst things, and I don't know I haven't found the right person to educate me to dispel me of this, but I have understood from what I've seen, victims that are evaluated, they get into this psych evaluation, they want the other side to be evaluated, so they'll agree to be evaluated too. It's the worst mistake ever. Women, victims of abuse who are psych evaluated will look like they are crazy on paper. And I don't use that term in a proper way, but that they are paranoid, that they're themselves, that they're just they're overprotective. They're all these negatives that come out of their truthful answer when you're gauging them against the abuser, who in many instances could be sociopathic, and answering their questions. They're not concerned about it. They believe everything they write. and they look like night and day, and nobody wants to believe that this stuff happens. Nobody wants to believe that these people are capable of
It happens.
committing these atrocities and being abusive like this. And oh, but they look so, you got the whole string of people coming in to testify about what great fathers they've seen them with them. It's all a show. And they may never say anything negative about the other parent, but there's going to be enough mudslung or a report drawn out that says this person won't, she doesn't want the child to go with the father. I've got that now. So because my client's trying to protect her son, he's not coming with you. He doesn't want to go, and you are not properly interacting with him. You're making him miserable. Threatened to call the police on the kid for no reason. And this kid is very sensitive. My client is going to have to deal with it, but those are things that happen. I've had other cases and people calling that the people who are supposed to be helping are literally berating the child for not getting out of the vehicle, berating the mother for not dragging her out of the vehicle when the child is in clear emotional breakdown, pure panic. And
Yeah.
they're all blaming them instead of trying to understand why this is. Oh, because you had a nice conversation with the father who just wants to see his kid. That means he can't possibly be this person. He can't possibly cause these reactions in the child. Of course they can.
Right.
But it's a lack of, and these are mental health professionals, mind you, who are supposedly trained in child welfare and understand these things. And it just blows my mind on how much more I am seeing this.
Me too.
That I praise the section and the Office of State Court Administrators for what they did last year in going around to every circuit and doing this trauma-informed training. But sadly, no judges, none. My circuit, I think we had 3 judges. As in many things, you're preaching to the choir. The people that needed to be in that room.
It has to get
were not
mandatory.
there.
It has to be mandatory.
And they're not, and
Yep.
it wasn't mandated. That's exactly right. And the judiciary and the chief judge will tell you, and the judiciary will tell you, they can't make us do anything. The judge can't require. And if you don't have a strong leadership from your administrative judge, you have that too. It's lead by example. And some haven't. But in the end, they can't make them. So the only the thing about Caden's law is it says, if you make them, we will pay for it. And I cannot understand for the life of me why a judge would not want to go through a training going to make them a better judge and
I
respect
agree. I don't know why anyone wouldn't do all they can.
to do their job the best they can. But that's life. That's the way it is. And people are, I don't even know how to explain it. It's not just the judiciary. It's not just the lawyers. It's everybody in any job. That's not my job. I'm only here to call balls and strikes. So I'm not here to make you feel better about being here. Nobody's trying to make anybody feel better. We're just trying to make it not a horrific experience, because going to family court these days can be a horrific experience. And it shouldn't be. It's a scary proposition. You can be anxious, but it should not be horrific. And I have had people who have had to say,
It shouldn't. It should be amicable for the child, but
that takes the people. But the system itself as an adversarial system isn't necessarily an amicable one, but it doesn't have to be unnecessarily so. If the judiciary takes the lead and if they take control and they don't allow it to devolve, at least when they're in their courtroom or when it's presented to them that it's getting out of hand outside the courtroom, that can manage. Now, of course, they're under ridiculous time constraints. Seriously, the Supreme Court said in 2001 that a divorce should happen in 6 months. You tell me where on earth that could happen.
yeah, that
Certainly
never happens.
you're talking about 5 people's schedules minimally. You have children's issues, financial issues, proof issues, documents, evidence, all. It's not even possible. If you're lucky to get mandatory disclosure within 6 months, you're lucky. Everybody's has a life. The lawyers should not be required to sit at their desk 24/7. They all have to manage their own quantity of cases and be responsible. They shouldn't take cases they can't handle, and they should be honest about that. And if they don't have a support system built in, I don't take cases for months at a time because I know that I don't have the support system to
A lot of lawyers do not do that. They overload.
Because if one isn't paying, then the other will. And there's ebbs and flows in the process. But if you have all of these kinds of cases, if I had cases like I have now, 3 or 4 of those, you can't do more than that. You just can't realistically with one paralegal. And because there is constant involvement with your client. So
there should be.
I agree.
Yeah. But everything that we just discussed happened in my case. I could talk about it all day because there were many injustices that I'm sure you already agree with. But I really appreciate you coming on and sharing with our audience that side of things and your approach, and especially when it comes to trying to get the abuser help, which is important. Yeah. Thank you. And you did say that you were on the Divorce Coalition.
Oh, yes. I am a member of the Palm Beach County Domestic Violence Coordinated Community Response Team. And that is every agency, everybody that deals with domestic violence in the county. We meet, we have training programs, we have all kinds of things we've done. We've been doing this now for this last year was our first work year. And we've got more stuff on the horizon. And we are going to renew what we call the Accountability Committee. And that is where information and things are done related to the abusers. And we should have more defense lawyers involved. We don't. It would be great if they could come. And we have BIP providers, but we also have, like I said, all of law enforcement, because it's the Criminal Justice Commission spearheads a lot of this. So they have made it so that everybody that gets dollars from them has to participate. And that means we have chiefs of police, and we have every department that has a domestic violence liaison is there. And then we have all the social service agencies and so forth. And the goal of that team is to reduce intimate partner violence and its impact on families and the community through education, advocacy, and accountability. And then I just recently was appointed to the board of the National Divorce Coalition. And it is an organization made up of all kinds of divorce-related providers whose mission is to improve divorce for domestic abuse survivors and eliminate re-traumatization and for the survivors going through the divorce process specifically. We don't provide direct services. We are working on the training end of it, doing all kinds of cool things. And it's got a great board, direct and at large. So I'm very happy to be involved. I'm
going to put all of your contact info and all of these organizations in the show notes for everyone have, and so they can find it. And I will definitely be in touch with you so we can talk more. But if you have anything else to say?
No, I just be safe, everybody.
It sounds easier than done, but all right. Thank you, Robin. I really appreciate talking with you.
Thank you, Allie, for having me. I appreciate it.
Absolutely. If there's someone that you want to hear from on this podcast, please feel free to send me an email. Or if you would like to be a guest, please reach out at Allie@graysonschoice.org.